We are diving into a neighborhood dispute that pretty much went nuclear. This is the story of a homeowner who, get this, was also a board member, taking on her own HOA. And it was all over one simple request. She just wanted to see the financial records. Believe me, this was not just some squabble over landscaping. This feud went all the way to a formal hearing. So it really all boils down to this one question, right? What do you do when the very organization that's managing your community's money just seems to be hiding the books? It's a situation that, thousands of homeowners unfortunately face, and this story is a perfect look at exactly how it can all play out. All right, so let's meet our petitioner, Deanna Smith. Now, as a member of the Moondance HOA board herself, you would think she'd have a front row seat to all the financials. But she claimed the exact opposite was happening. She alleged that her own board was actively blocking her from seeing even the most basic financial documents. And just look at this timeline. It shows you how a pretty simple request just dragged on, and on for months. It kicked off verbally in November 2022. By December, she put it in a formal email. Come January, she actually had to email them again to remind them about the 10-day response period required by state law. Finally, after feeling like she was just getting the runaround, she filed a formal petition. So you can see this wasn't a rash decision. This was the end of a very long, very frustrating road. You can just feel the frustration in this quote from the hearing. She's basically saying, look, I asked for this multiple times. If my request was confusing, why didn't somebody just ask me to clarify? That silence she was getting, well, it felt intentional. She had to assume her request was perfectly clear and was just being ignored. But of course, every story has two sides. So what did the Moondance HOA have to say for itself? Well, their defense wasn't about malice or secrecy. It was, they claimed, about pure, simple messiness. Wow, this is a pretty stunning admission from the HOA's own attorney. Right out of the gate, they framed this not as a refusal to cooperate, but as just a terrible misunderstanding. And then here comes the bombshell, admitting the board is somewhat dysfunctional. This really sets the stage for a defense built on chaos, not conspiracy. So, the core of their defense was a technical nightmare. The HOA had just switched from their old management company's software over to QuickBooks. They claimed the two systems were just not compatible, data was missing, and their volunteer treasurer was completely struggling to make sense of it all. They argued they weren't hiding the books were just a complete and utter mess. Okay, this is where things get really murky, because now we have two completely different versions of reality. You have one person saying the information flat out isn't there, and the other side saying it's right at her fingertips. This is the mystery the judge had to somehow unravel. So here we have it in an email from Deanna Smith. She says, crystal clear, that the shared Google Drive, the exact place the HOA president told her to look, is a total dead end. She's looked, and there's nothing there. This is a direct challenge to the board's entire story. But then, check this out. Just a few days earlier, this is the email from the HOA president, George Minter. And his position is the complete opposite. He's claiming that as a board member, Smith has full access to absolutely everything on that same Google Drive. It's all there, he says. You just gotta go look. So who is telling the truth here? Let's just break this down side by side because it is pretty stark. Smith says, the Google Drive is empty. The HOA says, no, it's full. Smith says, the profit and loss sheet you sent me is incomplete. The HOA says, well, we gave you what we had. Smith says, my specific requests were ignored. The HOA claims, we totally complied. It's like they're living in two different realities. And then came this. This might be the nail in the coffin for the HOA's story. It's a crucial email from another board member, which Deanna Smith presented as evidence. This person completely backs up Smith's story, saying that as far as they knew, the financial reports had never been on the Google Drive. This piece of evidence seriously undermined the HOA president's claims. So, with these conflicting stories and all this mounting frustration, it all came down to one person to sort it out. Let's take a look at how the administrative law judge cut through all that noise and delivered a final binding decision. And you know what's funny? The entire case, everything, ended up pivoting on this one question. It wasn't just about access to documents anymore. It was about the very definition of the documents themselves. The HOA thought financial statement meant one thing, Deanna Smith thought it meant another. But at the end of the day, the only opinion that really mattered was the laws. And it turns out, under Arizona law, a financial statement is not just some simple profit and loss sheet. Nope. It's a whole comprehensive set of documents, balance sheets, statements of cash flows, statements of income, the whole shebang. This very precise legal definition was way broader than what the HOA seemed to understand. And you know what? It changed everything. So the judge looked at the law and then looked at what the HOA actually provided. And it was no contest. The HOA had only sent over profit and loss statements. They completely failed to provide all the other legally required documents. At that point, it didn't matter if it was a misunderstanding or a technical problem. Legally, they had not fulfilled their obligation. Period. And that failure? It had a price tag. The judge ordered the Moondance HOA to reimburse Deanna Smith for her $500 filing fee. This wasn't just a slap on the wrist. It was a clear financial consequence for not complying with the state law. So the final ruling was decisive and a clean sweep. First, the judge sided with Deanna Smith. Her petition was affirmed. Second, the HOA had to cut her a check for that $500 filing fee. And third, and most importantly, the judge ordered the HOA to finally provide the complete, legally defined financial statements. It was a clear and total victory for the homeowner. So why should you care about this one neighborhood dispute in Arizona? Because the lessons that came out of this apply to literally anyone living in an HOA. These are the key takeaways you need to know. Honestly, this case is a masterclass for homeowners. First off, document everything. Deanna Smith's emails created the paper trail that won her case. Second, know your rights and use them. She cited the specific state law and its 10-day rule, showing she absolutely meant business. And finally, understand that those boring legal definitions can be your best friend. The HOA's misunderstanding of what a financial statement really is, that was the very thing that cost them the case. This whole entire ordeal started with just one person asking to see the numbers. And it leaves us with a really important final question for you. If you asked to see the detailed financials for your own community, would you get them or would you get the runaround?